My guest today here is Attorney Colonel Airth. And Colonel, welcome back to the show.
Well, thank you, Tom, for having me.
Colonel, one of the things you do is debt collection and protection from debt collectors, and I know you had a successful case defending a client last week based on the Fair Debt Collection Act. Tell us about it.
Yes, I did. Well, it's kind of interesting. It started several years ago with a debt collector hassling them, writing them letters once a month, called them a time or two, so they brought it to me. And I sent the debt collector a letter. I have a kind of a standard letter. It's always a little bit different, but a standard letter that in effect says these people. You have the reference has the account numbers and that kind of the people's names, and then you tell them that they've hired me, that the debt is disputed. The word disputed is important because that goes to the credit bureaus, and it shows that while it's still there, it does show that it's disputed. At least it's supposed to. And that my client doesn't want to be called or contacted any further. That any further contacts got to come to me, and so they're pursuant to the Fair Debt Collection Practices Act, which is the FDCPA, as lawyers call it. And so that was it. That was like 2 or 3 years ago. Then suddenly, out of the blue, they got another letter from them 2 weeks ago. They brought that letter to me, and I said, same company, same everything. So somebody's probably screwed up, I guess, because as far as I know, this particular company is a relatively good company. But anyway, I said, well, I'll handle this on the basis this is a violation, because it is, in fact, a violation. The Fair Debt Collection Practices Act, among other things, that it restricts, once the collector knows that there's an attorney involved, then they cannot directly contact the debtor, the alleged debtor. So it's a clear, absolute violation. The Fair Debt Collection Practices Act sets out that if you violate it, the minimum damages to the debtor, if you will, or the person who owes the money, is $1,000. Plus, the person can get costs and attorney's fees if they have to file suit or involve an attorney. So this person came to see me. We had a conference. We'd had conferences before, as you know. So I figured I had a couple of hours fiddling around talking to these people and the conversations I'd had with them, so that when I wrote to them, I told my client that I would charge them $500 for representing them. I don't know if I'm supposed to mention amounts, but for representing them in this matter, I wrote a letter to the company, told them, listen, I attached my letter from 2 years ago. I attached what they'd sent, and said this is clearly a violation, and the damages are $1,000, and that I've charged my client $500, and so we demanded if they don't want to answer a lawsuit, then they need to settle for the $1,500. They wrote back and said, okay, we will, and this past week we got the check with $1,500 in. So it's just one of those situations where everything came together. I'm confident that if I had sued them, not only would my client have gotten $1,000, unfortunately their damages are set. My damages, or the attorney's fees, are based on the amount of time and effort you put into it. So if you'd file suit, then I'm sure that my attorney's fees would probably have been $2,500, more than the $1,000. And if it happens more than once, of course, the damages are $1,000 every time it happens. So I have a client that we're contemplating suing now that's got 5 of those kind of letters, and after I'd written to them and told them not to contact them directly. So we anticipate once we make the demand that we'll either settle, then they'd get more than I did in that case. But if we don't settle, then we anticipate suing.